Hello, I'm Charlotte Geesin, Head of Employment Law at Haworths, and welcome to part 6 of our redundancy focus video mini-series. This is the final video in the series, and I'm going to run through some FAQs about redundancy this time around. Over the past 6 months or so, we've received a lot of inquiries about redundancies in light of the pandemic situation. And we're expecting to see that trend continue as the furlough scheme comes to an end in the next couple of weeks and the job support scheme is phased in. I have selected maybe 10 or 12 of the most commonly asked questions that myself and the team have come across in the last 6 months or so, and hopefully, therefore, the content of this video will prove to be of assistance to many of you. Okay, so launching straight in, question number 1, FAQ number 1. In what situation might an employee be made redundant? So starting right at the beginning, the law states that a genuine redundancy situation occurs in just 3 situations. 1, when a business closes down completely. 2, when a place of work closes down. And 3, where the employer requires fewer employees to carry out work of a particular kind. This third situation is perhaps the most common situation, and it includes the restructure and reallocation of work across an existing team, as well as the complete removal of a certain role within a structure, or where an employer is seeking to reduce headcount in a particular department. Question number 2. What may trigger a redundancy situation? Well, in theory, there's probably quite a lot of things actually that can trigger a redundancy situation, but perhaps the most common ones are a recession or other economic pressures, changes in the nature of the products or services provided by a business, internal reorganisations, relocation of a business, and things like technical developments or other business-related changes which have an impact upon roles carried out by employees. Question 3. What is a standard redundancy process? How long is a piece of string? Probably. The answer to that question, though, will ultimately depend on the number of employees that an employer plans to dismiss by reason of redundancy within a 90-day period. If there are more than 20 employees, then an employer must follow a statutory process, the collective consultation process, which I talked about in a previous video. But if there are fewer than 20 employees, then there is no statutory process. However, an employer must still act fairly. In terms of the statutory process, the collective consultation process, where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less, then the employer must, as I say, collectively consult about the dismissals of the affected employees at least 30 days before the first dismissal takes place. Those affected employees are referred to ultimately as being at risk of redundancy. As part of the collective consultation process, employers must consult with recognised trade unions, if applicable, or existing employee representatives. If there are no representatives in place, then those employees must be afforded the benefit of being able to elect their own employee representatives, and the employers must follow the associated election process, which again is set out in the statute. An employee representative's role is to represent the views and opinions of those employees at risk of redundancy, and also to act as a conduit between the employer and the employee body. Employee representatives can, if they wish, seek employment law advice on the redundancy process and any payments that may be made to employees that are dismissed by reason of redundancy. An establishment, which is relevant, it's referred to specifically in the statute, means the unit to which the employees have been assigned. It isn't essential that each unit should have its own management, which could have carried out the redundancy process itself, and consequently, therefore, collective consultation may not apply, and an employer will have to consult on an individual basis, which is not, obviously, like you say, governed by a statutory process. In terms of that non-statutory process, where there is no obligation to collectively consult, an employer must provide individual consultation to those employees who are placed at risk of redundancy. An employer must discuss planned changes with each employee and get their ideas and feedback for avoiding redundancies before it finalises its planned changes. An employer must therefore never start off a consultation process by advising an employee that they are definitely redundant. The reference must always be to the employee being at risk of redundancy, because in theory, through consultation, anything may change. If an employer is seeking to reduce the number of employees doing the same type of work, then the employees will need to be placed in a selection pool. Selection criteria will need to be devised, and a selection process will need to be carried out. If an employee performs a unique role, and that role is at risk of redundancy, then they won't normally be in a selection pool as such, although they'll be in a selection pool of one. And the need for the selection criteria and the actual selection process will fall away. Next question. Do we have a choice as to what selection process is followed in a redundancy exercise? In situations when the business is intending to dismiss as redundant some and not all in the pool, then unless there is a contractual process which sets out the selection process to be followed, and don't forget that this can be implied by previous redundancy processes, then generally speaking, the answer to this question is yes. However, as this element of the process is ultimately primed for challenge, it should always be approached carefully. And usually we would advocate the input of some legal advice in terms of the crafting and the division of the selection criteria. Some employers opt to implement a scoring system which is designed to identify those to be dismissed for redundancy. And examples of potentially fair scoring criteria will include performance and ability, attendance records, and disciplinary records. Examples of scoring criteria that should be approached with caution, as they can underpin unfair dismissal findings, include more subjective criteria, such as employees who, in the opinion of management, would keep the company viable, or employees best suited for the needs of the business. Cost-saving exercises without sort of a clear business rationale underpinning that can be problematic. Criteria relating to attitude can be suggested as being ambiguous and vague, and sometimes length of service can also be a problematic area, particularly if you are looking to make redundant those employees who were last in, because statistically they're going to be your younger employee, and you may through implementation of a last in first out type criteria inadvertently expose yourselves to claims for age discrimination. Can we select candidates for redundancy from amongst the part-timers only? The answer to that is no. Part-timers are entitled to exactly the same employment rights as full-timers, and that includes the right not to be singled out for redundancy. The law regarding full-time work versus part-time work is a little bit tricky, but ultimately it is unlawful to treat part-timers less favourably than full-timers unless you can justify the different treatment on objective grounds. Moreover, I suppose if most of your part-timers are women, which tends to be the case across the nation's sort of workforce, then you will risk an accusation of indirect sex discrimination if you do not have that objective justification. Is it reasonable to select people for redundancy on a last-in, first-out basis? So I've just touched on this already. And I suppose what I would say on this is ultimately be careful if you do. There's nothing wrong as such with taking that approach. However, as I've just said, such a criteria is likely to be unreasonable if newer workers taken on by the company tend to be younger than older workers. And the reason for that is as a last-in, first-out criteria will then disproportionately affect a particular sector of your workforce and will therefore run the risk of being discriminatory on the basis of age, again, unless you can show that the application of last-in, first-out is objectively justified. Last in, first out is also likely to be discriminatory if it affects those in your workforce of a particular gender, as I've said, sex being perhaps the most common one in that respect. But also don't forget that the Equality Act extends protection further. So things like gender, race, sexual orientation, including transsexual people, religious or philosophical belief, or disability. So tread carefully with a last in, first out criterion. I would say that if you are going to use a last in, first out criterion, then you should use it alongside additional and arguably more important and weightier criteria, or as a tie-break criterion where it is necessary to separate two individuals whose scores are equal on all of the other objective criteria that you have used. Perhaps the $64 million question: what can employees do if an employer fails to follow a proper consultation process? What's the risk? The answer ultimately is that any dismissal resulting from an unfair or a non-existent process could ultimately lead to a successful claim for unfair dismissal. If you fail to follow a collective consultation process when you would be obligated otherwise under statute, then in addition to a potential unfair dismissal claim, you could also find yourself in tribunal facing a claim for a protected reward from each of the affected employees, which can be up to 90 days gross pay per employee. That said, compensation for unfair dismissal can be reduced by a percentage under what is referred to as a Polkey deduction, where an employer has been found by an employment tribunal to have nevertheless acted unfairly in dismissing an employee, but where they believe that had the employer followed a fair process, the outcome would have ultimately have been the same. If a tribunal concludes that the employee may have been dismissed anyway, then it can reduce the compensation on an unfair dismissal claim based on the likelihood as a percentage deduction. Therefore, if a tribunal finds that a dismissal was absolutely inevitable, compensation could be reduced by 100%. However, that is unlikely in practice. Next question. Former employees are claiming that redundancies were not genuine because we have subsequently taken on more people. Do we need to worry? I think the answer to that question ultimately depends on the context in which the redundancies took place. For redundancy to be considered a fair reason for dismissal, you must be able to demonstrate that there is a genuine redundancy situation. Going back to the very start of this video, the first question, a genuine redundancy situation will present itself where you have closed or intended to close the business where your employee worked, you have closed or intend to close the place of business where your employee worked, and or there is a reduced requirement, or you expect there to be a reduced requirement for your employee to carry out their work. A redundancy situation then can't arise merely as a result of a downturn in business in itself, but it can also arise in the expectation of such a downturn. And if you can demonstrate that you had a reasonable expectation that the business in which your former employees work was about to cease, or the former workers' work was about to cease or diminish, then even if you were wrong, you will actually have a defence against their claims. However, if your ex-employees can convince an employment tribunal that you use the pretext of redundancy to get rid of them where there was no genuine redundancy situation, then they may indeed succeed in bringing a successful unfair dismissal claim. An employee only actually has 3 months minus 1 day from the date of their dismissal, however, to bring a claim for unfair dismissal. So if you took on the new employees over 3 months after the dismissal of the ex-employees, then technically they'll be out of time to bring an employment tribunal claim in relation to this anyway. So tactically, some employers will take the approach that they will place a freeze on any recruitment following a redundancy process until after that deadline has passed, just to be absolutely certain that they will not be facing any tribunal claims relating to the dismissal process in the unfair dismissal sense. If an employee is dismissed by way of redundancy, what are they entitled to receive? So an employee who has been employed for a minimum of 2 years and who has been dismissed by reason of redundancy, they will be entitled to a tax-free statutory redundancy payment, which is calculated based on age, length of service, and gross weekly wage, which is capped at a maximum weekly amount. If an employee earns less than the cap, which usually changes once a year, upwards, then the statutory redundancy payment will be based on their actual weekly pay. The multiplier depends on the age of the employee at the time of their dismissal, and employees who are aged 41 years or more at the beginning of the year will receive 1.5 weeks pay for each full year service. They'll receive 1 week's pay for each full year in which the employee was between the ages of 22 and 40 at the beginning of the year, and half a week's pay for each full year in which the employee was under the age of 22 for any part of the year. The maximum length of service that may be taken into account is 20 years. And in addition to a statutory redundancy payment, where applicable, an employee will be entitled to either work their contractual or statutory notice period, whichever is a higher, or receive a payment in lieu of working their notice, subject to any contractual provisions relating to such. An employee will be entitled to receive a payment for any accrued untaken holiday pay, in addition to redundancy and notice, calculated up to the date of their dismissal. When it comes to enhanced redundancy payments above the statutory redundancy payment amount, usually this is at an employer's discretion. However, an employer's approach may be set out in a redundancy policy, or it might be set out in an employee's contract. Either way, if an employer is seeking to make an enhanced redundancy payment, then the employer might want to give some consideration to making the employee sign a settlement agreement in exchange for that enhancement. If an employer does do that in order to gain additional protection, because under a settlement agreement, an employee will waive the vast majority of their employment rights. So if you do make an enhancement with a view to the employee then not suing you, there can be no comeback if such an agreement is in place. Then it will be a legal requirement that an employee takes advice, normally from a solicitor, on the terms and effect of signing such an agreement. The employer will have to make a contribution towards the legal costs in providing that legal advice, which usually is between sort of £350 and £500. Next question. We are in financial trouble and will not be able to meet our redundancy payment obligations. What happens? If you are unable to make your statutory redundancy payments because the company is insolvent, then those payments will be paid to the employees out of the National Insurance Fund. If your employees are entitled to more than the statutory payments, then they join your other unsecured creditors in waiting for whatever assets can be released from the business. Employees will usually need to take their own legal advice in respect of any claims from the National Insurance Fund. What are our obligations in respect of alternative employment, and what is classed as suitable alternative employment? So the answer to this question ultimately will differ to some extent from business to business, but ultimately all employers are under an obligation to give consideration to whether any suitable alternative employment exists within their business when they are consulting with an individual about a redundancy. The obligation on employers is not to create or actively find alternative roles for that individual, but to provide them with information, allowing them to consider whether any alternative vacancies within the business might be suitable. Therefore, it's really an employee sort of question to be answered, I suppose. The vacancies may exist either at the time of the consultation meetings, or they might become available at any time whilst the employee is serving a notice period, assuming they're going to remain employed by their notice period. So it is important always to remember that the duty to look for suitable alternatives extends past the point of the notification of termination being given and up to the termination actually becoming effective. In assessing whether a role is actually suitable alternative employment, the employer will need to make an objective assessment of the role. This will include considering the employee's skills, attitude and experience, as well as the terms of the alternative job, including things like status, pay, hours, location, and responsibility. Employees are legally entitled to a statutory trial period in the alternative role before concluding whether or not it is indeed suitable for them. Next question. Is bumping permissible in redundancy situations? Bumping in a redundancy exercise is where an employee whose own position is redundant is actually transferred to another position that is not vacant and which has the effect of making the holder of the second position redundant. Redundancy bumping is legally permissible as long as the correct procedure is followed in respect to the employee that is bumped out of their role. If you are looking at bumping, then you should take some employment law advice on that to ensure that the process is indeed fair. But ultimately, if the reason for the redundancy / dismissal of the second person is a diminution in work resulting in the need for less employees, then although the reduction in work does not relate to the employee that is ultimately made redundant, it can be linked as a result of the bumping exercise. Next question. Do we have an obligation to offer voluntary redundancy schemes? The answer is no, unless there is a contractual obligation to do so. However, I personally am a big advocate of offering voluntary redundancy schemes to employees because it can avoid the need for compulsory redundancy consultation, which ultimately helps protect against legal claims, but also it can really help with staff morale because particularly when an employee can perhaps see the writing on the wall in respect of a proposed redundancy situation, it also stops them from having to go through, the genuine upset of being taken through a compulsory redundancy process. There is no doubt that a redundancy situation, particularly in the context of where the country, the world is at the moment with COVID-19, that it's a difficult time. It's a difficult time for everyone, employers and employees alike. So anything that you can do to kind of take the pain away from compulsory redundancy proceedings, I think is only ever a good thing. The voluntary redundancy process is actually an application process. So subject to how the voluntary redundancy is handled, then an employer will not necessarily be under an obligation to accept any applications for voluntary redundancy. So if someone applies for VR who actually you would prefer not to exit on that basis, then you can legitimately, usually, reject that application and continue with your consultation. Are we allowed to, or obliged to allow redundant individuals time off to seek alternative employment? The answer to this is yes, if the employee has more than 2 years service. In this instance, an employee who is given notice of their dismissal by reason of redundancy has a statutory right to take a reasonable amount of paid time off during working hours to seek alternative employment or to arrange training for future employment. There is a wages cap in these circumstances, and I would encourage you to take some advice in terms of paid time work off to seek alternative employment. One employee has tried the alternative employment we offered and says it's not suitable, and is now asking for the redundancy money. Do we have to pay them? Provided that the employee has decided that they do not want the job within 4 weeks of trying it, or within a maximum of 8 weeks if an extension has been pre-agreed, then the answer to this question is yes. The employee will be treated as if they were dismissed by reason of redundancy on the date that their old role ended, and they must receive their usual entitlements, including a redundancy payment if applicable. What are the key risks with redundancy? So the main claims that employees may bring upon termination following a redundancy exercise are, without a doubt, unfair dismissal and unlawful discrimination. Other claims can include a failure to collectively consult and or to make a redundancy payment. Potentially breach of contract claims might also be borne out of a redundancy process if an employer fails to follow any contractual provisions that they have with regards to that process. But it's the unfair dismissal risk which is the overriding risk in a situation like this. For these reasons, it is therefore imperative to ensure that every effort is always made to follow a fair process when it comes to redundancies, and that dismissals by way of redundancies are only made where there is a genuine redundancy situation. Further, due to the additional obligations imposed by law in instances where an employee in the pool is on maternity leave or on long-term sick, then the process will need adapting to ensure that the process is legally compliant and meets, obviously, the employer's risk tolerances, in order to ensure that additional exposure to risk can be avoided, hopefully. That was the last question, and therefore brings this final video in our redundancy focus mini-series to a close. I hope that you have enjoyed this video and indeed the series, and if you do have any questions at all about any redundancy related issues, then please do not hesitate to contact us on 01274 864 999. We'll be more than happy to help. Additionally, if you have a look at our website, howarth-uk.com, you can learn more about us and exactly what it is we do and the type of support that we can look to provide to you and your business. Thank you very much for watching.